Hello, before we get started, let us first introduce ourselves.
I'm Claire Gilroy-Scott, and I'm a partner in the employment team at Goodman Derrick.
I'm Emily Kersey, and I'm a solicitor in the employment team at Goodman Derrick.
We've recently presented workshops covering some common HR horrors. This is the third session, and in this session, we consider whether you can decline delving Derrick's demand for a diabolical degree of data. This session is on data subject access requests, how to deal with them, and the changes to the process in May 2018. Under the DPA, employees can make data subject access requests. These are relatively easy to make and are often done by employees who are fishing for evidence prior to making a claim, but they can be very problematic and time-consuming for employers. Please note that the reason that the employee makes a request is not relevant, and the ICO has made it clear in its recent June 2017 Code of Practice that even if there is a collateral purpose for the request, you still have to respond to it. Here we're going to cover current law and guidance, and there is a slide at the end outlining changes in May. First, we need to remind ourselves about the sort of data that Derrick might be after. Personal data is data which relates to a living person who can be identified from the data, and it includes any expression or opinion about the individual or indications of your intentions in respect of the individual. It's information which relates to the person in their personal, family, business or professional life, and where the individual is the focus or theme of the information.
So, in this scenario, you receive an email from Derrick which says, "In accordance with the data protection laws, please provide me within 40 days with a copy of all documents you have on me. Is this a valid SAR?" Well, it may be. Looking at the requirements for a valid SAR will be in writing, which includes email and fax, but there is otherwise no prescribed form. If you want, you can request a fee of up to £10, and the request won't be valid until this is paid. You should be satisfied as to the identity of the data subject, but asking for confirmation of identity has to be reasonable. So, in this scenario, Derrick is your employee, so you are likely to know him. However, in other situations, you should not assume that the person making the request is who they say they are. You could ask for a copy of their passport or driving license to confirm this.
Now, Derrick's request for everything on him isn't very precise. However, the ICO Code of Practice indicates that a request in these sort of very general terms for all information that is held is still a valid request. However, you can ask Derrick to provide sufficient information on the data requested so that you understand what is being requested in order to be able to find it. For example, is the information requested contained in emails? If so, what's the relevant time period he's looking for? If the information requested isn't sufficiently clear, you can ask for more details to help locate it. Now we're going to consider if there is any information on Derrick that you do not have to disclose to him.
So, assuming that you do receive a valid SAR from Derrick, there are some documents that you may legitimately exclude. There are exemptions from the duty which relate to, firstly, the nature of the personal data, or, secondly, where the disclosure may cause prejudice to a part or function of your organisation, and this must be a substantial chance of prejudice, not a mere risk. If you rely on an exemption, you should explain that information has been withheld and the reasons why, which is stated to be good practice by the ICO. So let's think about some of the possible exemptions in a little more detail.
One possible exemption relates to management forecasting and planning. This could include, for example, where you're in the process of planning a reorganisation and there are documents which identify Derrick, but these also outline the likelihood of other employees being made redundant. If these were disclosed, there would be a substantial risk of prejudice to your ability to carry out this process properly. However, this sort of exemption wouldn't cover an historic redundancy process where the outcome would not be affected. Remember also that you can redact information which identifies other employees.
Another possible exemption concerns confidential references. So, a reference which you have given or are to give in confidence in relation to Derrick's employment is exempt from a SAR. However, the exemption does not apply to the reference when it is in the hands of the recipient, so Derrick may use a SAR to the future employer, for example, to see a reference that you have given about him. He can also use the SAR to see references that you received about him from a previous employer.
Another possible exemption relates to documents relating to settlement negotiations. If you have records of your intentions in respect of negotiations that have taken place or perhaps are still taking place with Derrick, these are exempt to the extent that the disclosure is likely to prejudice those negotiations. And it would cover, for example, a document prepared by your business which sets out the highest that you would be willing to pay Derrick in order to settle a possible claim.
A final exemption concerns documents containing legal advice or which relate to legal proceedings. You do not have to disclose data over which there is legal professional privilege. This includes confidential communications between you and your professional legal advisor. Now, moving on, what are the timelines for responding to Derrick's request?
The current requirement is that you must respond to a valid request within 40 days of the request. However, if you have requested a fee or other reasonably required information, you must respond within 40 days of receiving any requested fee or information. However, the ICO guidance states that you should not delay making any requests for a fee or additional information just to obstruct Derrick or the process. Let's briefly touch on the scope of the search you need to undertake. If data is difficult to access, you can't just exclude it, and your search must be reasonable and proportionate. This could mean a very extensive search, but it does not necessarily mean no stone left unturned.
With electronic records, make sure you consider appropriate search terms, such as Derrick's name, initials, or employee number. Check archive and backup records. You're required to check archive and backup records, but you're not obliged to recreate deleted information. In terms of hard copy records, you'll need to search those included in a relevance filing system, for example, personnel folders that are searchable. It's good practice to provide a basic explanation of the scope of the search undertaken when the information is provided.
We're now going to go through a checklist as a reminder on the process for you. Firstly, consider if the request you receive is a valid SAR. Do you have sufficient evidence of Derrick's identity? Do you need more information? Do you require a £10 fee? Then check that the information requested is personal data relating to Derrick. If not, respond to Derrick requesting the fee and/or clarification. Remember to note your 40-day response deadline.
Then examine the information you find and remove duplicates and irrelevant information. Check whether the data contains third-party information. If so, think about whether you can redact the information or whether you can seek third-party consent. If not, is it reasonable in all the circumstances to disclose the information anyway? Now, this is often a balancing act and should be considered on a case-by-case basis.
You will then need to consider whether there is any exempt data. If there is, explain your refusal to provide any information and keep a copy of the withheld data and the reasons for it. Check also whether Derrick wants hard copies of the data or an electronic copy. Provide all information in an intelligible and permanent form. And finally, make a copy of what you send.
As a final point, we've set out on the slide changes to the Sar process which is coming in next year. So, from the 25th of May 2018, under the GDPR, employees, as data subjects, will have the right to access the personal data that you process on them, and should receive a copy on request, unless this would adversely affect the rights and freedoms of others.
The GDPR makes a few changes to the Sar process. If an employee makes a Sar, the employer must provide a copy of their personal data free of charge, but may charge a fee if additional copies are requested. The information must be provided electronically, if the Sar has been made electronically. A reasonable fee may be charged if the request is excessive or unfounded, or you may refuse to accede to the Sar. This is to cover the administrative costs of complying with the request. Employers must respond within 1 month of receiving the Sar. This may be extended by up to 2 additional months by informing the employee within 1 month of the Sar of the need to extend and the reasons why. And that's the end of our session looking at data subject access requests. Please do check out our next podcast where we consider when you might be able to suspend suspicious SAMI. Please also check out our LinkedIn profiles and follow us on Twitter @EmployHeroes. Bye.
Bye.